What's up, y'all? So it's been a while. I haven't been on YouTube and I haven't been making videos, so I'm long overdue. And I thought I'd just give you guys a video on the update of the RKelly trial. So as you guys may well know, there's been an update with the RKelly trial, and what's happened is that recently it's been revealed that they're going to ship RKelly from Chicago to Brooklyn for the trial that's scheduled in August. So they're scheduling his Brooklyn trial in August, and then interestingly enough, there's also going to be his trial in Chicago in September. So some of you guys may not realize the significance of all this, but I'm going to point it out, right? So the significance in this is that to me, the first thing that I notice is that there's a trial in August, and then 1 month later, there's a trial in September. Now, for those of you that have never been to court, that have never, had to, be involved in litigation, God bless you, you're blessed. But, for most average, everyday people who has been in court, who has been had to go back and forth to court, and who's been, trapped in litigation, you can understand the problem that RKelly is faced with here, right? So he's having a trial in New York in August, and then he's going to have another trial in September in Chicago. Now, the funny thing of all this is that he's actually going to be shipped to New York in August and then come back in September for the trial in Chicago. Me personally, I would just ask, why not just have the Chicago trial first and then have the New York trial sometime after second, right? So the importance of all this, in my opinion, and this is just my opinion, I'm not sure if this is done on purpose. Of course, we all like to say that, there's a conspiracy theory out there where, they're trying to, wear RKelly down or wear his defense team down. And this situation is set up just to do that, right? Because essentially, whenever you have a trial, you're going to have a brief period in time of which you can do something called a reconsideration, or you can modify the judgment. And I talk about that in another video, right? So I'm going to, hopefully, if you look above now, there'll be a link to a video series that I created called How to Escape a Judgment. And in that video, I talk about a motion for a new trial. I talk about a motion to amend the judgment. I talk about a motion to vacate, right? So the reason this is important is because you have 30 days to do this. You only have 30 days, right? There's other things that you can attempt after 30 days, but for the most part, you want to take full advantage of that 30-day period to, get in all the different options available to you, right? There's lots of options available to you in order to deal with a bad judgment. And that's what that video series talks about, how to escape a court judgment. If you haven't seen it, there should be a link above now. You want to check that video series out. And essentially what I've done is I've tried to modify it for each state. And if you want a video modified for your state, questions and comments below in this video or in that video series, and I will, try to accommodate you. Of course, donations always help to move things along. But getting back to RKelly's situation, once you have a judgment against you, it's not the end of the world, and it's not over. There's lots of options you have available to you to deal with that judgment. And it doesn't matter if it's a judgment where it's civil judgment or if it's going to be a criminal judgment. It doesn't matter. For the most part, the mechanics for handling judgments against you are going to be the same. And you got 30 days, right? You got 30 days to deal with that. And again, I point out the options for dealing with, judgments against you in that video series, so check it out. So you got 30 days. Then what you can also do is that you can appeal. right? So there's two different paths that you can take. There's one path where you're going to go back to the court to enter to judgment, and you're going to say, hey, I don't like this judgment and we need to do something about this. I'm oversimplifying this, right? Of course, you have to have the legal language in there to show why the judgment was bad, right? And I talk about that in the video series. So that's one path. You're going back to the court. The second path is that you just appeal. But here's the thing. You only have 30 days to appeal a judgment. Otherwise, you lose the right to appeal. That's actually crazy, and I think they should probably modify that rule to say maybe 90 days, because 30 days is too short of a time. But in my personal opinion, the way they have this set up, RKelly could potentially lose if he runs out of resources, or if the lawyers in his case aren't paying attention, which I don't think would happen. I think, from my personal opinion, he has good lawyers, and I've liked some of the things I've seen them come out and do, especially with some of the motions that they filed for the New York case, right? But anyway, RKelly could potentially lose his right to go back to court and try to modify or vacate the judgment. And he could also lose the ability to appeal the judgment. So for the most part, like I said, you only have 30 days to do both. Now, there's a tricky thing to all this, right? In that if you take the first option, which is to go back to court, and you go back to court and you try to ask the court to throw the judgment out, you can ask the court to stay the judgment, you can ask the court to modify the judgment, or you can ask the court for a new trial. You can say, hey, we had this trial, but this trial was 100% bogus for reasons A, B, C, and D, right? So you can go back to court and do that. But here's the thing. Here's a trick to all this. When you go back to court and you go back into court and you ask the court to vacate or modify or whatever it is that you're going to ask them, when you go back to court and try to get remedy, you extend the time that you have to appeal. You extend the time that you have to appeal for an additional period of time. Now, it's kind of tricky, because what happens is that you have what you call post-court judgments. And with post-court judgments, what happens is that there's new litigation. So essentially, whenever a court puts in the judgment against you, that court is going to lose jurisdiction, which is the right to hear the case. But like I said, if you go back before 30 days, you can grant that court, or you can reinvest the court with jurisdiction, if I'm using the right word there. But essentially, you can reset the jurisdiction of the court. And because you've reset the jurisdiction of the court, you're going to extend the time that you have to appeal the judgment. And the amount of time that you have to appeal is going to be dependent upon the time it takes to exhaust your post-judgment motions, right? So essentially what I'm trying to say is that you could, number one, you can stay the judgment itself, right? So in most jurisdictions, well, in some jurisdictions, when you file a post-judgment motion, or when you file a motion after the judgment has been entered, and if the judgment is timely, if the motion is timely, then you're going to stay, meaning you're going to prevent the court from executing the judgment, right? So in some cases, that doesn't mean that you're going to get out of jail. RKelly in this case is already in jail, so I doubt that they're going to allow him to come out of jail if he is convicted. And I'm not saying he is going to be convicted, right? And again, I should have said that up front. I'm not saying that RKelly is going to be convicted. I think that he shouldn't be convicted, and I'm going to make arguments why the federal indictment in New York is not a strong indictment against R. Kelly. I'm going to make an argument for that, but for the most part, if he goes back within 30 days, he files a post-judgment motion, he can get a new. So several things is going to happen. Number one, he could get a new trial if that's what he desires, but beyond that, he can also end up in the situation where they can't actually execute the judgment that's been put against him, right? So I'm not saying that he's going to lose, but if he did lose, filing a timely post-judgment motion could extend the time that he has to fight this, right? So let's say, hypothetically speaking, he loses, and then he files a motion to vacate the judgment, which is actually going to be relevant again to the video series I've done, How to Escape a Court Judgment. I've covered that in very good details of the options available for R. Kelly to actually vacate his judgment. Maybe I'll look into that after the trial. Maybe we can look at what the options are after the trial if R. Kelly loses as it pertains to R. Kelly. But generally speaking, you can watch that video series now to see what the options are, right? So let's say, hypothetically speaking, he loses. Then he can come back a week later, 2 weeks later, in New York, and he can file a motion to vacate the judgment. And when he files a motion to vacate the judgment or a motion for a new trial, he can also ask the court that they stay the execution of that judgment. What does that mean? Essentially, that means that he can ask the court to have a new trial, and while they're preparing for the new trial, he could potentially ask that he be released on bail again, right? Now, unfortunately, because of the history of R. Kelly's bail situation, that may not be granted. But in my opinion, it presents a new opportunity, a fresh opportunity for him to ask for this relief. And what's going to help him get out on bail in this situation will depend on how the trial goes. If the prosecution presented a really weak trial and the evidence shows that the trial is weak, but somehow he was convicted anyway, or he was convicted on the technicality, then he can point those issues out. He can point those issues out and he can say, well, hey, you can see according to, evidence A, B, C, and D that was in the trial that, the case against me is weak. And because of that, I'm asking that, the court let me out on bail, right? So that's potentially something that, he can ask for. Then once he files that motion, he's going to get new court dates, and it's going to take time to go through the post-judgment motions. And, I'm not going to put a time frame on it, but essentially, this could pretty much play out for another 6 months to a year, right? It could potentially play out to another 6 months to a year. And, he could be out on bail as it pertains to the New York trial. Now, of course, all of this could be for naught if R. Kelly doesn't have enough time to prepare for the post-judgment motion, or B, the appeal. Now, with all this said, you don't have to go directly for the post-judgment motions. You can just appeal directly. But in my personal opinion, in my experience, you want to go for the post-judgment motion because you want to kind of test your arguments. You want to see how strong the prosecution's defense against your post-judgment motions are going to be, and then you can appeal from there, right? So in other words, you can perfect your arguments in the post-judgment trial, and then once that is denied, you can make better arguments in the appeals process, right? So if that makes any sense. The other reason I would go for the post-judgment motion first is because you have more cards to play, right? If you directly appeal it, then you're essentially just playing that one card, and that's the appeals card. But if you file the post-judgment motion, and it may just be denied, especially when in this day and time when you have judges that are biased against you, that judgment may just be denied, but yet it's still another card to play. So you're playing two cards instead of one, right? And then, of course, there's always the Supreme Court of New York or the Supreme Court of whatever the state you're in at the time. So that is essentially three cards instead of maybe two or one card that you would play. And then another reason that I think you should go for the post-judgment motions, or at least RKelly should, is that sometimes the appeal court likes to see that you've given the judge a chance to correct any potential errors that the judge has made in the case, right? Sometimes they like to see that, but maybe that's not a good reason if your appeal has very little to do with the judge's errors or mistakes and more to do with the laws or the statutes that are against you. Then you may just say, hey, I'm just going to go straight to appeals court. Or you may just want to go straight to appeals court if there's a situation where the judge is biased, and it's obvious the judge is biased, and you can easily prove that the judge is biased, right? So that's the big picture on all of this. So I would say with RKelly in this case, hopefully he doesn't lose. I'm praying he doesn't lose the New York case. But if he does lose, then but if he does lose, he has cards to play. But all of this will, again, be for naught if he doesn't have time to file the post-judgment motion. All of this will be for naught if he doesn't have time to file an appeal. And again, I think this is important because he's being rushed from Chicago, which makes no sense to me because you're in Chicago. Why not motion to have the trial in Chicago first and then the New York trial sometime after, right? Instead, they're going to take him from Chicago and ship him off to New York. He's going to have that trial. And then he's going to have to be, in my opinion, he's going to have to be immediately shipped back to Chicago for the Chicago trial, which is going to be 1 month later. So it takes time to actually file a post-judgment motion. It takes time to actually, figure out what your arguments are going to be in that motion. And it takes time to file an appeal. So how in the world are you going to be able to prepare for all that if you're being put in a situation where right after the trial you have to be shipped off to Chicago? You won't have time for that. You won't have time for a post-judgment motion, and you won't have time for an appeal, right? So this is all going to depend on RKelly's resources. Now, I can think about the time back when somebody told me to stop worrying about RKelly's money, but RKelly's money is going to be key to all of this because you're going to have to pay lawyers to handle this stuff. And if the lawyers are short of time, that can increase or maybe even decrease, more than likely increase the amount of money you're going to have to pay lawyers to file these post-judgment motions and to file an appeal. Now, in my opinion, I think there are some situations where litigants or defendants are held and ransom by lawyers because in order to file that post-judgment motion or in order to file that appeal, they're going to want some additional money to do that. So there could be a situation, hopefully RKelly wins all this, right? But there could be a situation where he loses and, the lawyers could at that point say, okay, well, it was nice working with you. Good luck on your appeal. Good luck on your post-judgment motion. If you want me to do any of that, I'll do it, but this is my price for that. The price that I gave you was just for the trial. That didn't include the price for the post-judgment motions. It didn't include the price for an appeal. This is the type of thing that happens sometimes that, you get held for ransom in a lot of these cases. And I think that, this is something that could potentially happen to RKelly. Even worse that could happen is that what I notice is that sometimes lawyers don't do appeals, right? Or they don't do post-judgment motions, right? So after the trial is over, they're off to their next assignment. They're off to the next project. And you're saying, well, hey, buddy, can you file, a motion to vacate? Can you file a motion to amend the judgment? They'll say, hey, I don't do this type of thing. You have to find yourself an appeals lawyer, or you have to go in and find yourself a lawyer that deals with post-judgment issues. And this is a reality. This actually happens, and this is the situation that litigants are placed in. So in that scenario, RKelly definitely won't have enough time to go out and find someone to handle the post-judgment motions, find a lawyer to handle the appeal, and at the same time, while he's being shipped back to Chicago for a September trial, right? So all of this is just kind of crazy to me. To me, it looks as though if he loses in New York, it's going to be hard for him to get relief after that loss, and that loss is going to be permanent, right? If you don't file a post-judgment motion, and if you don't appeal the judgment, then that loss is permanent. There's nothing you can do, right? So hopefully RKelly is talking to his lawyers now, and more than likely, I hope, right? I don't know, but I hope, and more than likely, the lawyers are lining up a strategy for the end game, right? We'll just call it the end game, right? So hopefully RKelly is having an in-game conversation with his lawyers, and hopefully that is going to include how they're going to deal with a situation where he loses in New York. That's it for this video. Let me know what you think. Do you think there is enough time for RKelly to finish up his trial in August and then get back to Chicago? Do you think he'll have enough time to file a post-judgment motion if he loses? Do you think he'll have enough time to appeal? What would you do in this situation, right? What would you do if you were in RKelly's situation? You had to consider filing a post-judgment motion or an appeal if you lose in a situation like this. How would you plan out this situation, and how would you deal with a loss and then having to immediately be shipped off to another state? Me personally, I would file an emergency motion right here, right now, to line everything up and just say, hey, the logistics of this thing is unrealistic. I'm due in Chicago. First, I'm doing August in New York, and then in Chicago in September. I have a right to be heard, and part of being heard is the ability to be able to file a post-judgment motion and appeal, and that's going to be impossible to do with the schedule that I have before me. So I'm filing this emergency motion so that we can reschedule everything, so we can line up a reasonable court dates, for this trial. That's what I would do right here, right now. Let me know what you would do. That's it. Thanks for watching. Please like, share, and subscribe.